When did you start smoking dope? When did you start smoking marijuana?
When?
Yeah. Dude, get your hair out of your face. Yeah. I'm better. I can see you now. I can pretty much paint the picture of your life for the next 5 years. Okay? You are like the poster child for Mr. Laid Back. Wow, you got me with your logic on that one.
Today's courtroom session delivered drama that was as sharp as it was inevitable. At the center of it all was Judge Oakley, facing down a young defendant who walked in with the air of someone convinced the rules of the justice system didn't quite apply to him. The young man's swagger suggested he thought consequences were optional, but the judge's firm expression told a very different story. Patience had run out, and reality was about to arrive in full force. What unfolded wasn't just a routine hearing. It became a pointed reminder that the courtroom is no stage for theatrics or bravado. The defendant carried himself as though the entire setting revolved around him, but the weight of the law quickly underlined just how small that spotlight really is when accountability takes the stand. Judge Oakley, no stranger to this type of defiance, made it clear that this time there would be no easy escapes, no dismissals of responsibility, and no tolerance for arrogance. The exchange turned into both a cautionary tale and a sobering wake-up call. In moments like this, the courtroom doesn't just hand down rulings, it delivers lessons meant to echo far beyond the defendant's immediate case. Whether or not this young man finally takes the judge's warning to heart is uncertain, but one thing is clear, the law speaks louder than ego, and today it spoke with unmistakable force.
Come on up, Mr. Vick. Mr. Vick, are you going forward today without benefit of a court-appointed attorney?
No.
Where's your attorney then? Who's your attorney?
I don't have one.
Then you're doing it without one, right?
Yeah.
Do you want to do it without one, or you want to talk to one of ours?
I'll do it without one.
Okay. Dude, get your hair out of your face. Yeah. I'm better. I can see you now. All right. All right. I've got a ticket here, and the prosecutor says you're going to plead responsible to double parking, and we're going to dismiss a misdemeanor charge of reckless. Is that correct?
Yes.
That's the way you want to resolve this today?
Yes.
Okay. How old are you?
17.
All right. I understand you're almost done with school?
Yes, sir.
Then what's your plan?
I've been trying to get a job ever since I was 7.
Stop right there. Stop right there. Where have you been trying to get a job?
I'm trying to get a job at the service yard at Holiday Inn at the apartments.
Okay. Why do I have a ROA for a double parking? And we've already got a double ROA for it? Oh.
So everything.
It's confusing. No, it's not the way I'm used to saying it. I thought we had 2 tickets going. Okay. All right. Where else have you looked?
I looked at the bait shop in Logo,
Okay.
and I also looked at Walmart and Buffalo Wild Wings.
And nobody's hiring you?
Well, Walmart, I don't know, but I can't get a response from Buffalo Wild Wings, and I'm trying to go to the holidays.
Okay. Okay. All right. You got a driver's license?
No, sir.
Yeah, transportation's going to be an issue then. All right. So what's your long-term plan? Done with high school, then what?
I'm trying to be an engineer.
So you're going to school somewhere.
Hopefully, that's.
Where and when?
Well, I graduated this year, and maybe I hope to go to college. Maybe by the time I'm 19.
Okay. What are you waiting for?
Nothing really.
Then why aren't you going to college now? As soon as you graduate?
I'm trying to finish school right now.
No, as soon as you graduate.
As soon as I graduate.
Yeah. Why aren't you planning on being in school somewhere in the fall?
I mean, I really didn't think about that, but.
When did you start smoking dope?
The signs in this case almost speak louder than the testimony. Observers could see immediately that the defendant appeared far from focused, moving slowly and with heavy eyelids, as though he was detached from the reality unfolding around him. There was a vacant look on his face, one that suggested distraction or disinterest, and it starkly contrasted with the seriousness of his surroundings. It carried the impression of someone who had been on autopilot for years, unable or unwilling to break from a troubling routine. While a calm demeanor is never out of place in court, there is a clear line between composed and careless, and in this instance, the defendant's presentation crossed it. Arriving in front of the bench with the appearance of fatigue or indifference did little to inspire confidence that he was respecting the process. A courtroom isn't a late-night hangout or a stage to appear detached. It is the one place where clarity, accountability, and full attention are not just expected, but demanded. Moments like this raise difficult questions. Is the young man truly so disconnected that he cannot grasp the gravity of the situation, or is he trying to project a posture of calm in the hopes of earning understanding? Whichever the case, the optics were poor, and the judge could hardly overlook them. The scene served as yet another reminder that in court, how a defendant carries themselves can be as telling as the charges they face.
When did you start smoking marijuana?
When?
Yeah.
2 years ago.
Okay. How often you hit it?
That often.
What's that mean?
Like, barely.
What's that mean? Give me a frequency, brother. Once a month, once a week.
Speak.
Okay. All right. So on this file, you're not working now, so I'm not going to give you money. I'm not going to charge you fines and costs. I'm going to charge you community service hours. But I also have to give you a little lecture. Dude, I've been doing this a long time. All right? I can pretty much paint the picture of your life for the next 5 years if you don't do something drastic. Okay? You are like the poster child for Mr. Laid Back. All right? If you're talking about going to school when you're 19, I can guarantee when you're 21, you'll still be talking about going back to school. Guaranteed. I mean, I would bet $100 of mine against one of yours that by then you could come back and we'd still have this conversation about your planning on it. Okay? If you were my nephew, I would put you in a car. I would drive you over to Canton on Ford Road. I would walk you into the recruiting office where you can talk to the Army, the Navy, the Coast Guard, Air Force. They're all in one building. And I would have you go door to door to door and find out what they could offer you if you sign up. Because that's what you need to do. You need to completely shake up your life to make something happen. Have you ever considered it? And I know you don't want to cut your hair, but it'll grow back. Have you ever considered it? Why not? Why? Because that's a valid reason. Wow, you got me with your logic on that one. Listen to me. How are you going to pay for engineering school?
Okay, well, if I get a job, I can pay for it. You know?
No, you can't. You can't pay for an engineering degree working at Walmart. You can't. If you join the military, they'll send you to college. You know, every one of the branches of our armed forces have engineers. There are Army engineers, there are Navy engineers. That's a plan, dude. You don't have a plan.
Okay, well, the officer that got me fired, well, I did have a plan, but the officer that got me fired, he should be the one getting it done.
Officer got you fired.
Yeah.
Okay, where were you working?
The USC fellow.
Okay, and how did you mean a cop?
Yeah.
How did the cop get you fired?
He was a member at the USC, and when it happened, I guess he thought he had to reach the
You mean when this happened? Okay. All right. Okay. So I'll give you that. Okay. How's that change what we're talking? We're not talking about this case now. We're talking about your life. How's the cop getting you fired determine whether or not you can afford to go to engineering school?
Because I wouldn't have a job to pay for.
The BYC isn't going to pay for 4 years of college, dude. What were you making? $15 an hour?
I mean, I was making about $14,000 a year, so I mean,
that ain't even going to cover tuition.
Surprising turn. The defendant informed the court that he earns roughly $14,000 a year and even had plans to pursue college had it not been for losing his part-time job. On the surface, the claim seems far-fetched, almost like equating the loss of an entry-level paycheck with the collapse of an ambitious academic journey. The logic doesn't quite align, and without any real documentation or preparation to back it up, the explanation feels more like a shaky attempt at sympathy than a realistic roadmap to education or stability. Yet beneath the uneven story, there's another layer that can't be ignored. Watching the young man's body language, hearing the way he addresses the court, it becomes strikingly clear that he has probably navigated much of life without strong guidance. The absence of a father figure or mentor seems etched into his demeanor. His words hint at independence born out of necessity, not choice, and a lack of accountability that has followed him into adulthood. Judge Oakley, notably, does not dismiss this reality. His tone reflects more than authority, it carries concern. He isn't merely enforcing the letter of the law, he's attempting to break through. Every pause and carefully chosen phrase is deliberate, aimed at sparking recognition in the defendant's mind. It feels less like punishment for its own sake and more like an intervention designed to draw a line between where the young man has been and where he could go. But despite the effort, the defiance lingers. The defendant presents himself as someone almost immune to authority, unmoved whether the words come from teachers, law enforcement, or, now, the judge himself. His college aspirations sound less like a plan in progress and more like a dream slipping further away the longer he resists responsibility. For those watching, the question becomes unavoidable. Can this young man still pivot his life with the right guidance, or has he already set himself too deeply in a pattern that no authority figure seems able to break?
Okay, well, I'm also an advocate, so, the state would pay for it.
Okay.
Okay.
I'll see you again. 30 hours community service, have it done by February 1st. Goodbye.
The harsh reality is difficult to ignore. There's little indication this young man is prepared to make genuine changes anytime soon. Chances are, he'll leave the courtroom and slip right back into old patterns, as if the hearing never happened at all. And that is what makes his situation so troubling, a reflection of how many young men today drift without anchor or direction, moving from one poor decision to the next with no firm voice of guidance to redirect their course. This is the result when structure and accountability are missing. Instead of treating a moment before a judge with the gravity it deserves, it is approached with indifference, like the courtroom is just another casual setting and the authority of the bench is negotiable. But legal consequences are fixed realities, and failing to acknowledge them only accelerates the inevitable. For individuals who arrive unprepared and unchanged, the pattern almost always ends the same way, with justice catching up, often harder the second time around. Even Judge Oakley noted with a candid edge that he expects to see the defendant again, a statement that hinges not on cynicism but on the clear pattern unfolding before him. The lack of urgency, the absence of remorse, the casual attitude, each one tells its own story, and none of those stories point toward lasting reform. It's a sobering picture of what happens when potential collides with stubborn resistance, and how quickly second chances can become wasted opportunities.